Welcome. Today we'll be providing an overview of the Australian legal framework. All the information we're covering is drawn directly from our source document titled The Australian Legal Framework. Let's begin. Our agenda is structured into 6 sections. We'll start with the fundamentals, what a legal system is, and then progress through the types of law, key commercial principles, the court structure, its participants, and finally, we'll conclude with the core principles of justice that underpin the entire framework.
So to begin, Section 1, Introduction to the Legal System. We'll start by defining what a legal system is within the Australian context. According to the source material, a legal system has 2 key components. It's not just the laws of a country, but also the procedures that are put in place to ensure those laws are actually complied with. So you can think of it as both the rules themselves and the system for enforcing those rules.
Now, Australia's legal system has several distinct features, and the source document points to 4 key ones. First is the segregation of powers, meaning the body that makes the laws, Parliament, is separate from the body that interprets them, the judiciary. Second, we use an adversarial system for fact-finding in our courts. Third, Australia is a common law country, which means that judges can, in fact, formulate law through their decisions. And fourth, a cornerstone of our system is the presumption of innocence for any criminal charge.
All right, that brings us to our second section, the 3 types of law. Here, we'll look at how laws are made and categorized. So, what is a law? Well, the source defines laws as rules that are enforced by either the executive or judicial branches of government. A crucial characteristic is that they are applicable to everyone, without exception. In Australia, there are 3 main types of law. The first is statute law, which refers to acts that are passed by Parliament. The second is what's known as delegated legislation. These are rules and regulations made by the executive branch, but under the authority granted to them by Parliament. And the third type is common law, which is law created by judges through the decisions they make in court.
It's really important to understand the difference between statute law and common law. Statute law is written law that is formulated and passed by Parliament at either the federal or state level. It's often called an Act of Parliament. Common law, on the other hand, is created by judges to fill in the gaps where written law might not exist. It's based entirely on judicial decisions from past cases.
Moving on to our third section, we'll now examine some of the key principles of commercial law, looking at the legal doctrines that govern business and finance.
Let's start with a foundational one, contract law. The source defines this as the law that comes from a promise or a set of promises that form an agreement between 2 or more people. The key here is that these promises create obligations that a court will actually enforce.
For a contract to be considered valid, it has to have 3 core foundations. The first is an offer, which is a clear expression of a desire to enter into a contract on very specific terms. The second is acceptance, which is the final approval of those terms. And the third is consideration, which is defined as something of value given by both parties to secure the promise.
Now, let's see how this works in a practical financial services context. Take a lease offer, for example. The estimate provided to the client, that's the offer. When the client signs the terms of agreement, that constitutes the acceptance. And the consideration? That would be the fees charged for the advice or for the service itself.
Of course, contract law isn't the only principle. There are other foundational concepts. There's equity, which are principles that complement rules of law to prevent unfair outcomes. Then you have the law of agency, which deals with fiduciary relationships where an agent acts for a principal. There's also the law of torts for civil wrongdoings that happen outside of a contract, often revolving around negligence. And finally, there's fiduciary duty, which is the essential duty to always act in a client's best interests.
Okay, that brings us to Section 4, Australia's court system hierarchy. Here we're going to look at the structure and authority of the nation's courts.
The entire hierarchy of our court system is built upon a central legal principle called the doctrine of precedent. What this means is that decisions made by judges in higher courts become binding rules that judges in lower courts are required to follow. This is absolutely fundamental to how common law works.
Now, under this doctrine, there are 2 types of precedent. First, you have binding precedent. This is a decision from a higher court that must be followed by lower courts within that same jurisdiction. Then you have persuasive precedent. This is a decision from a court at the same level or maybe from a different jurisdiction. It can be influential and considered, but it is not mandatory to follow.
So, what does this hierarchy look like at the federal level? Well, here are Australia's principal federal courts, listed in order of hierarchy. At the top is the High Court of Australia. Below that sits the Federal Court of Australia, then the Family Court of Australia, and finally, the Federal Circuit Court of Australia.
All right, let's move on to Section 5,
court participants and processes. In this section, we'll identify the roles and procedures within our adversarial system. The terminology used for the parties in a legal case is very specific, and it differs between criminal and civil matters. In a criminal case, the party bringing the case is the prosecutor, who represents the Crown, and the party responding is the defendant or the accused. In a civil case, however, the party bringing the case is called the plaintiff, and the party responding is the respondent.
As we mentioned, Australia operates under an adversarial system. This is a crucial point. It means the judge acts as an impartial referee. The court passes judgment based only on the evidence that is presented by the two opposing parties. The judge doesn't conduct their own investigation.
And that brings us to our final section, number 6, Core Principles of Justice. Here, we'll touch on the foundational values that underpin the entire legal system.
These are often referred to as the principles of natural justice. The source material outlines 5. First, fairness. Decisions must be based on predetermined, known rules. Second, transparency. Legal processes should be accessible and understandable to the public. Third, equality before the law. Every single person is treated equally, regardless of their status. Fourth, freedom from bias. Decision-makers absolutely must be impartial. And finally, the right to be heard. Any party affected by a decision has the right to present their case.
And that concludes our overview. But it does leave us with a significant question to consider. In a system that relies so heavily on an adversarial process and the doctrine of precedent, how does the law adapt? How does it handle new and novel social and technological challenges? It's a critical question for the future of the framework.